Even worse, you understand that the maximum penalty for you could be up to 15 years.
Yeah. Yes.
Knowing all of that, it is still your desire to represent yourself.
I've been instructed by a constitutional attorney, John Whitehead of the Rutherford Institute. He's famous. He told me that the worst thing I could do is give up my right to act as my own attorney.
I don't know who that person is, and he's not here in the courtroom, and he doesn't represent you.
I'm just saying.
You told me you represent yourself.
That's why he told me to represent myself.
Okay.
This guy goes on television. John Whitehead, Rutherford Institute.
He's not here, so all I need to know is that you are knowingly representing yourself, correct?
Yes.
All right, that being the case, then Ms. Stamble, you are standby counsel for Mr. Schwartz. Mr. Schwartz, from here on out, you are representing yourself, and unless and until there comes a point in time during the proceedings that you are disruptive, you are basically creating a ruckus in the courtroom, or you won't follow the court's orders. Do you understand that?
Mm-hmm.
Is that a yes?
Yes.
All right, you're going to hear me repeat that over and over and over again. And so with that being the case, then what today is really what's called the final pretrial conference. And so I wanted to make sure that everybody understood that we are in fact scheduled to start trial next Tuesday. And so what we need from you, Mr. Schwartz, I have been handed copies of the proposed jury instructions, because every trial, as far as the court is involved, I'm sort of the referee, and I watch what happens with the witnesses and the questions and those sorts of things. But before we get to that jury trial, every person in your shoes, every litigant, every attorney has to submit to the court in advance of a trial a witness list. And so I have been handed a copy of a witness list, and it begins at the top. It says 3-13-23. Is that something you prepared, Mr. Schwartz?
Is that the? Yeah. Yes, that's it.
Okay, and it says, I want officers and myself to take polygraph tests to end this trial real quick. That's what you wrote?
Yeah.
Okay.
That's a fair question. And I just added that, and the problem is, sir, I had to make 266 evidence videos that are acceptable to the court, and it took me 4 days, and Nolan told me that Thursday, and I worked on it ever since Thursday, and I finished it up this morning, so that list is kind of ragged up, and I apologize, I would have done a better job.
Well, what I need from you, sir, I'm going to hand this back to you. I need you to sign it, because there are rules that govern what happens in courts.
Okay.
If you sign that, that means that you're agreeing that you're bound by those rules.
I got it.
If you would put today's date on there too, please. And Mr. Schwartz, have you provided a copy of that list to Mr. Fitzpatrick on behalf of the people?
Do you have it?
I have it.
Okay.
All right, very good. And then one of the other requirements is that you provide the people of the state of Michigan and a copy to the court of a proposed exhibit list, not your exhibits, because you talked about videos that you have, but an exhibit list that says what those videos are. Do you have a list?
I didn't understand it that way. I said, the thing is, I made these on YouTube, and this goes up back to 1970.
Your Honor, if I could just speak to this. Mr. Schwartz did advise me that he has, is it 266 videos that are on his YouTube channel that he wished to introduce as exhibits. I had explained to him that it wouldn't be appropriate to introduce a link as an exhibit and that he would need some type of hard copy. So he has been diligently working on getting those videos onto an external hard drive so that there would be some type of tangible hard copy of the exhibits that he wishes to introduce. I do not believe he prepared a physical list of what those videos are.
All it is a chronological list that goes back to where this all started.
Well, the allegations in the felony warrant that was originally issued against you indicates that the events that are involved in this case occurred on September 8th of 2019.
Right.
So, I mean, videos prior to September 8th of 2019 wouldn't be relevant.
But it's all relevant.
Okay.
It's all relevant because this is a culmination. They arrested me. This was a culmination of me making complaints about Lapeer County employees' gross negligence. They destroyed my house, did $15,000 worth of damage, and signed me up for Social Security Part B against my will and without a signature. And between those, they did $15,000 worth of damage. And if I live to be 90 years old, the Part B will cost me $65,000 that I never wanted. And that's how this all started out in 2017. And I started, they blew up my house, cut me off, I had no drinking water for 2.5 years. They destroyed my house and tried to cover it up. That's what it was. It was a cover-up. The former prosecutor, Mike Sharkey, tried to cover it up. And wouldn't let you cannot make a complaint against a Lapeer County employee. They make it impossible to do it. And I tried. I don't want to get in trouble again.
And Your Honor, in speaking with Mr. Schwartz, I think what he's really trying to explain is that there's kind of a greater history, and that this history affected the conduct of the police officers on the date of this alleged incident. That he alleges he was unfairly targeted by the police, and that their motivations were impure because of these other previous events. Is that fair, Mr. Schwartz?
Mm-hmm.
And so that is what he wants the jury to be able to understand, as it would go towards the bias of the witnesses.
There we go. That's something I understand.
And see, I also went.
My turn.
Okay.
So you may have all of these videos that you want to try to introduce at trial. That's a different issue for me right now. What I need from you is a list of what those videos are. What is it? I mean, what's on that particular video? Is it video of Judge Nolan walking across the street on March 13, 2013?
Well, that's what you
need to tell me what it is on your exhibit.
What I did is I made the videos, and then I gave a caption, the date and what happened. It's on each one of these videos.
Okay, perfect. Then you need to put that on a list and give that to Mr. Fitzpatrick for the people, and a copy with the court. You have to sign it again, and it'll say Mr. Schwartz's exhibit list. Number 1, video of Mr. Schwartz on whatever day it is, doing something. What is it that you're doing? It sounds like you have that information.
Yeah, I do.
Well, you have to put it on a list.
I got it on a list. I got it on a disk drive, and
What he wants is like a list, like number 1 through 266, where you would say on video 1 it's this, on video 2 it's this, but he wants all of that on a list, like your exhibit.
And when am I supposed to do that?
I think he's going to tell you when he needs it.
You need to put all that on a list, and you need to get that to me no later than Friday. Because here's my concern. I have a genuine concern, based on what you're telling me, that you're going to try to use or introduce into evidence things that I'm not going to think are relevant. Or that may be relevant as to one issue, but not to the issue that we're here in this trial. That's why I need that list. I need to see sort of a preview. Okay, what is it? Because what I can't allow you to do is just stand up and play a video when none of us in the courtroom have any idea what it is. You can have a video of planes hitting the World Trade Center on 9/11 for all I know. And if I don't know what that is in advance, how can I say that it has anything to do with the case?
See, I thought I did it. I thought that would do it, because if you take a look at my disk, my hard drive, it's got the video, and then below it, it says the date, and then it says a caption of what it's about.
Okay, and I understand that. And so that's what I was saying to you earlier, Mr. Schwartz. That's part of the rules of the road here.
No, that makes sense. I completely concur with what you're saying. It makes sense. I thought I did it, and I thought that that's acceptable. If you want, I can go back, and I'll one by one, I'll put a description, and then the date, and then I can email that to you by Friday?
No, you have to somehow file an original with your original signature with the court. I don't know how you go about doing that. We don't have...
I'm 3.5 hours from here, sir.
Well,
I don't live in this county anymore.
That's why you have someone like Ms. Stamble who is here and can help you. I mean, these are part of it, and here's my concern for you and about you.
If you email it to me before Friday, I can bring a copy with me to court. So if you can email it to me, I can get it to the court for you. I'm going to be here on a different case on Friday. So if you
With my signature?
So if you email it to me.
With my signature. What's the difference? I email it to you or him? Come on, let's...
The court only accepts things filed.
Transparency.
In a certain way. The court only accepts things filed in a certain way.
Okay.
One of them is in person. So I'm assisting you in getting it filed in person.
Okay.
Wow. So email it to me and I'll take care of it.
Okay.
All right, so you understand your job on the exhibit list?
Mm-hmm.
Then yes?
Yes.
All right. Then the third part of how we get ready for the trial is the prosecutors have prepared what are called jury instructions. But again, it's another very specific set of instructions that before your case starts, and then when your case ends, I read to the jurors. And so you all will help develop what the facts of your case are, but then it's my job to instruct the jury as to what the law is. And so part of how we arrive at what the law is we look at what are called Michigan criminal jury instructions. There's a set of instructions that are out there that are common in every case, where I read to the jury here is what you are to do now as a juror in considering this case. And so the prosecution has prepared a set of proposed jury instructions and given that to the court. You are required to do the same thing.
Your Honor, is this the instructions before trial and procedural instructions? I have gone over the people's proposed instructions. I advised Mr. Schwartz that I had reviewed them and that it is my recommendation that we adopt the proposed instructions that the prosecution submitted. And it's my understanding that Mr. Schwartz was in agreement that we could go with these instructions before trial and procedural instructions as submitted by the prosecutor's office.
Yeah, I trust you, yeah.
Okay, but then there's the third part. And the third part of the instructions are what are called composite instructions, which is the actual law in connection with the case.
And Your Honor, I did not receive a copy of those.
You should have, Ms. Nolan, know that my administrator assistant sent them today.
Oh, today?
Yeah, she sent them today.
Okay.
Yeah. So you should have received the updated version today, which includes the composite instructions.
Okay.
If not, let me know and I can certainly get it to you.
So, Your Honor, I've been advised that I would have received a copy of those today. If it's okay with the court, I'd like to be able to go over those with Mr. Schwartz, and perhaps we could let the court know if there are any issues with any of those instructions before Friday.
No, absolutely. Do you have an extra copy of this? Would you take a moment? Okay, so Mr. Schwartz, Ms. Stamel, we have actually, I'm told, an extra set of the composite instructions, so we're going to make sure you get those today. So you don't have to wait. There won't be any mystery to it. You'll have a copy of the instructions you can take with you. So if you give us just a moment, we'll do that. And then the last piece is what's called the jury verdict.
I'm sorry, the jury what?
The jury verdict form. That's a piece of paper that we give to the jury when your case is all done. All the evidence is in, all of the witnesses have testified. The arguments have been made to the jury as to what we think happened in this case and why you should or should not be found guilty. Then the jury, after they've heard all of the instructions, gets a piece of paper. And on that piece of paper, it basically says, as to count one, Mr. Schwartz is either guilty or not guilty. As to count two, Mr. Schwartz is either guilty or not guilty. That's something, though, the verdict form, I need you to agree that that is the proper form to be used, or I need you to give me a different form that you think is more appropriate. You understand?
You're in my head, but
I know, that's the problem. You're not a lawyer, and I understand that.
I could have been a lawyer in all the time that it's taken. I could, if I would have started taking classes, I would be a lawyer by now.
Never too late. You can always start.
Yeah, I wouldn't want to be a lawyer.
And Your Honor, I have not seen a proposed verdict form from the people, but if the court has one, I could review that with Mr. Schwartz. We could probably have an opinion on that today for you.
Mr. Fitzpatrick, do you have a copy of your proposed verdict form? Oh, you got it. Okay, very good. Probably, I haven't seen it. It's probably going to be pretty basic. Yeah,
This
either
just
guilty or not
says,
guilty.
you know, this lists the counts, count one and count two. Those are what the counts are called. And then it says, mark only one box, not guilty or guilty, not guilty or guilty.
Is this something I do now?
So this is just what will be given to the jury.
Oh, okay.
And when the jury reaches their
You got
decision.
my name wrong. I'm not Stephen Alan Schwartz. I'm Richard.
Well, that's a good correction. I'm glad you,
Right,
I'm glad you reviewed that.
You're after that guy.
So, Your Honor, in reviewing it with Mr. Schwartz, obviously we would ask that his name be corrected on the verdict form, but in terms of the actual form, the form itself, I think, looks okay. Would you agree?
Yeah.
All right, very good. I appreciate that. And Mr. Fitzpatrick, the only thing I would note is that on the bottom of the verdict form, after you make the correction to Richard Allen Schwartz at the top, and I see there's another spot on there where it says Stephen. If we can correct that, just make sure you put the date and the signature line for the jury form.
Will do, Your Honor.
Thank you. All right, very good. Well, I feel like we're making progress here. So then the next, I've gone over it with you exhaustively. You want to represent yourself. I understand that you're going to have an opportunity to do that. You have to it's like driving a car. You have to stay in your lane. As long as you stay in your lane during the course of the trial, we're going to get along great. And so that trial is scheduled to begin next Tuesday. I need you to put together that list of exhibits so we know what those things are.
By Friday.
Yes, by Friday.
Okay.
If you can get that to Ms. Stamel, I know that she can work with the court so we can get that. We're going to need to give a copy of the exhibit list to Mr. Fitzpatrick, and then we will be here next Tuesday ready for trial.
What time?
9 o'clock. I need you to be here next Tuesday at 9.
If I could, Judge, I also need a copy of the videos if I compare them to what he's describing them so that I can see what he's talking about.
Correct.
Also, in addition, I don't know if you've had a chance yet to look at his proposed witness list.
I really haven't.
I have. He has people listed on here, such as Senator Debbie Stabenow, legislator Gary Howell, all sorts of Secretary of State.
Debbie Stedman was the one that filed that
People
complaint.
that honestly have no knowledge whatsoever about any of the events related to these charges, and if he's going to ask for any of these people to be brought forth, he needs to describe in detail what they know and what they could possibly provide to this court that's relevant to these charges. I'd ask that he do the same thing, put some sort of descriptor of how these people are all relevant, and they're going to all have to be addressed, Judge. We're not bringing in Debbie Savanaugh in this case, or John Miller, or Mike Sharkey. I mean, these are all city prosecutors, former prosecutors. He would even list one of our administrative assistants that needs to come in. Just a whole list of people that have no knowledge whatsoever. The people that he does have on there that I would agree to are on my witness list, which includes Officer Wilson, Officer Best, and 2 people from the EMT service that provided medical care that day. Those people I would agree to on the list. Everybody else I would, at this point, say is not relevant to the case. And for the record, just so that it's clear, and because he pro per, I'm providing Mr. Schwartz with a copy of the people's witness list and a people exhibit list, and I believe we've already sent those to you, Ms. Stamen, but those are for Mr. Schwartz's record.
Every one of those people that on that list are part of this.
All right, so I think what we need to do is we need to, Mr. Schwartz, I need you to do the same thing with your proposed witness list that I asked you to do with your exhibits.
Sure.
Because you have a number of things on here that really aren't the names of people, you list things.
Yeah, but you don't know, sir. That's the problem. This case is the evolution of a 7-year battle with Lapeer County.
Listen to me, I'm not even arguing with you.
Okay.
Just listen. You have on here, for example, Governor Gretchen Whitmer's secretary. Governor Gretchen Whitmer's secretary is not going to be a witness in this case. I can tell you that.
Okay, then I want my witnesses to do that, because they're the ones, I made 7 calls to those people, and they were supposed to call me back. She's the one they're the ones, what I'm trying to do is get this case to Attorney General Danny Messel, because Danny Messel ran on a platform of protecting senior citizens' rights. And I'm not getting, this is a kangaroo court so far. That's why I'm hoping things will change. You've been very respectful, and I really appreciate that. I'm a human being.
You definitely are, I agree. For example, on your witness list, you say a witness is not Bill of Rights violations 1, 4, 5, 6, 7, 8. You know what I mean?
I'm sorry, what?
You have, this is what you said is your witness list? And on your
No, you know what, like I said, I did that real quick this morning, and I didn't have time, because I had to do 266 evidence videos, and I just finished up, and then I was trying to get that to look more professional, but I just ran out of time, sir, because this was a 3.5-hour drive for me.
I understand. I know it's not convenient for you, and I understand you don't live in the area anymore. But that part of it I don't have any control over. So if you live further away, I can't help you with that. But I think you would agree with me that the Bill of Rights is not a witness.
No.
So that's the kind of thing, I would like a list from you, just of the names of the people that you intend to call, and maybe a brief description of what it is that you would have them testify to.
No problem.
Okay,
Yep.
good.
Yeah,
So if I could have that by Friday also?
Absolutely.
Excellent. Because my goal here is that when we get to next Tuesday, we're actually trying a case and not arguing about all of this preliminary stuff. Because like you have said many times, and I've read many times in your file, you want your trial. And I want to help you get your trial. And so
I want justice, that's all. And what those people did, they're public servants, and they abuse a disabled senior citizen, and I could have got, they put me in jail. I went on a 2-week hunger strike. Then they threw me in a mental institution for another 2 weeks, and when I got back home, my cat was dead. My cat destroyed my house. We had starved to death. I want justice. And I was out of work for 5 days. These idiots, these criminals stalked me and arrested me and made to beat them up and tried to, this is all punishment. They $100,000 bail, and I couldn't get out, so I went on a 2-week hunger strike. Have you ever tried that?
Your Honor, if I could interject. This is my concern. This last 30 seconds, there's no way he's going to stop that behavior in front of the jury.
It all connects. You can't say, what you're trying to do is you're trying to say, it's all what happened at that particular time. You don't understand. The reason I got arrested is because Chief Andy Martin, I showed him Americans with Disabilities Act, my right for transportation to access public services, and he laughed at me. He wouldn't allow me. I had a warrant out for my arrest. That's why they were stalking me. And see, that's a problem. I'm having, and this has gone on. I've had it for a year now. I'm getting heart palpitations.
Take a sip of water and just take a minute.
No, I'm a victim. And I feel like a rape victim trying to justify my existence.
I certainly am not going to ask you to justify your existence in any way. Like I've indicated to you multiple times on the record here this afternoon, you have rights. We all in this room acknowledge your rights. I'm trying to help you get your right to a trial. I'm trying to help you exercise your right to represent yourself. I'm trying to help you represent yourself in the defense of this case. Mr. Fitzpatrick raises a really good point. And this is why we're doing this here today. If nothing else, this is practice for you. Practice for you should be, and you need to think about this when you leave here today. When you come back next Tuesday, you have to behave. And you have to behave in a way that is appropriate for the course of a trial. During the course of the trial, if you go off on a tangent about how you're a rape victim and if you call the witnesses idiots, I'm going to stop you. You want to be treated civilly, but you have to treat other people civilly as well.
I'm treating you civilly, sir.
I appreciate that.
And I would never call you an idiot unless you were acting like an idiot.
I understand that.
Okay, I'm only accusing the criminals that are the people that I'm calling know all about this case, and I tried to get water because I was out of water for 5.5 days. Why can't I call the 911 operator that I called the day before? And she told me, and I got a recording of that. Oh yeah, you always complain. Well, have you made her get you some water? And she hung up on me. Can I call her?
I'm going to leave that up to you. I have an idea about the answer to that question, but I can't try your case for you.
I tried to do, this is my crime. I tried to get water so I don't die. And a crisis is not a crime. And these people are trying to make it, no one touched anything. No one looked at any of my evidence. John Miller looked at my evidence. That's why he made me an offer to dismiss this case. He said he would make it disappear. He knows it's a fake case. That's why I wanted John Miller here. Instead, I've got this guy. He doesn't know anything.
Well, I know Mr. Fitzpatrick knows quite a bit about
He doesn't know about my case. John Miller is the one that made me the offer. I'm going to call John Miller and have him, why can't I do that?
Mr. Schwartz, again, this is my concern, and that's why I had to go through all of these people V. Anderson factors with you. I get that you don't understand the rules because you're not a lawyer. Believe it or not, we all went to law school and we actually had to...
Right, and
please listen to me, it's my turn. We had to have I've listened to you, I expect the same in return. We all had to have specialized training, so we knew how to act once we came through that door. Once we come through this door, things change a little bit. We don't get to call people names like we might out on the street. We don't get to have a temper tantrum if we get mad. We don't get to do that here. We have to follow the rules. You, for example, when you're representing yourself, if you have a question for a witness, you may ask the question. You can't argue with them. You can ask them a question. They're entitled to give you an answer. If you don't like that answer, you're not then going to be able to call them an idiot because they didn't agree with you. So there are rules, these are rules of the playground.
I understand that. I would never do that, and I would not try to disrupt this court.
I appreciate that. So I'm coming now back full circle. And you'll see it as we start the trial. I'm more sort of a referee in a ball game than I am anything else. My job is to try to make sure that everything that's happening here, don't speak, you're about to, is to make sure things are done fairly as best we can. One of the things that you're going to need to practice is when someone else is speaking, don't talk. I will pause, you'll have a chance to speak. If a witness is answering your question, don't interrupt, they have a right to answer. Just like if you are asked questions and someone asks you a question, you have a right to answer the question. So again, we have to treat each other with respect in this room. Understood?
I understand.
Very good. Witness list, names of people that you intend to call as witnesses by Friday. Exhibit list, that itemization, that list of things that you want to try to introduce.
The videos?
If that's what you have, then those are your exhibits, yes.
And how do I show the jury my videos?
Well, that's another part of the problem here. That's up to you to figure out how you show those videos.
I know that I guess there's two separate issues. The one is laying a foundation for the introduction of the videos. The other would be a technical aspect of physically playing the videos for the jury. Does the court have the technology to be able to allow Mr. Schwartz to be able to project it or to put it on the TV screen for the jury?
What the court will do is make that video screen and the connection to that video screen available to Mr. Schwartz.
So is there an HDMI cable?
There is.
Okay. So if he brings in a laptop computer, then he would be permitted to use that technology?
Absolutely.
And I could assist him with doing that?
Yes, absolutely.
So yeah, I've got to bring my laptop?
Yeah.
Okay, that's kind of dying.
Okay.
So, yes, we certainly will make the screen available. And then, just again, Mr. Schwartz, because you do not, have you ever tried a case before?
No.
Okay, so just as part of sort of the rules of the road, just keep in mind that just because you list the name of a witness, or just because you put a video on your exhibit list, doesn't mean you get to use it at trial, or that you get to call that witness at the time of trial. We'll make those decisions as the trial unfolds. And so if you want to call a witness, and I'll pick on Governor Whitmer's secretary again, because I remember seeing that name in here. If you stand up and you say, Your Honor, I would like to present Governor Whitmer's secretary as my next witness, then Mr. Fitzpatrick may have a right to object to you calling that witness. He may argue that witness has nothing to do with this case. I will listen to his objection. I will come back to you. I will give you a chance to respond to that. I get to make the decision whether I think that person has anything to do with this case at all or not, just so you know, okay? I may ask you to make what's called an offer of proof. You would have to tell me what this witness might have to add.
No, that makes perfect sense. That makes sense. I see what you're saying. I couldn't accuse you of something that had nothing, nothing to do with this case. Governor Gretchen Whitmer, I see. The thing is, when I had problems with Lapeer County, they destroyed my house. They caused Social Security fraud. I tried getting help, and I went to the Department of Civil Rights. I went to State Legislator Gary Howell's town hall meeting, and he had me thrown out. And he told me, he said, you got to go to Mike Sharkey and don't take no for an answer and sit on his doorstep until you get action. That's what they told me. And then so I went home and I called Mike Sharkey, and he hung up on me. So that's the kind of help that I got. And then I contacted my Senator Kevin Bailey. When I sent paperwork, I sent it to these people, so they're my hostile witnesses. But they got proof of that. Look how many times I've contacted these people, and it's all the same issue. They destroyed my house. I was out of water. That's what it was. And I went all the way up to Governor Gretchen Whitmer, and they were supposed to get back with me, and they know that it was the DHHS problem, and I sent them all the evidence and that, and they just wasted. They didn't bother even contacting me back. Now I voted for her too. Why would I vote for her again? That's the thing. This is a court, but we're all human beings. Why would we trust any politician that sabotages us? And that was the same thing with Gary Howell. And that was the same thing with John Miller. Mike Sharkey is a crook. Even John Miller told me he was a crook. John Miller told me that he tried to have him disbarred. So I thought when I met John Miller, I thought, man, this guy's a good guy. And he said, and I want to call Mike Sharkey. Mike Sharkey, when I became my own attorney in June of 2020, he knew all about it. And I contacted him for 6 months, and he didn't respond. I tried to file complaints against him and the Elmont police. You know it's impossible to file a complaint against a police officer in Lapeer County? It's impossible. Even the 911, they hung up on me. I've got videos of me calling. I had Elmont Police Chief Andy Martin. I said, I want to file a complaint against you. How do I do it? They said, you got to contact the state police. I called 911. The 911 operator is arguing with me. She's going, no, you don't do that. You got to go back to the chief of police and work it out with them. And I said, how do you work out a felony complaint? And she refused to send the state police. She refused to do it. And I got a recording of that too. And See, that's the thing. It's go to this one, go to that one, and nobody's in charge of anything. They told me to contact Adult Protective Services. I got a recording of the Adult Protective Services guy coming to my house with the plumber that destroyed my house, and all they did was fix it. They patched it, and I said, if you don't fix it, it's going to leak. And I said, if you don't fix it right, it's going to leak. And they walked out and refused to do it. And 4 months later, the thing leaked and destroyed my house. And this is and then I got recordings of this Adult Protective Service agent, Steve Atkinson. I told him, I said, look, they committed Social Security fraud. And I said, somebody's got to help me with this. Who is supposed to help me? They committed, a Lapeer County employee committed Social Security fraud, which is gross negligence. And who am I supposed to report that to? I filed a complaint, and I had an MAHS hearing, and I had 2 judges, and I got their names too. I went there with the whole intention was that we were going to talk about them destroying my house, and I walked into the court, and I got there, and she said, and they're telling me, oh, we have nothing to do. First she said, well, if they did something wrong, I'm going to get on them and get them to fix it. That was when I first started this court hearing. And then halfway through, I'm talking to her, and she said, well, the only thing we can do is work on food stamps and things like that, but we can't handle anything like that. So what was I supposed to do? And so then I filed a complaint against her with a MAHS Judge, and her name is on that list. I got both those judges' names. And they never did resolve, they never did investigate what this woman did to me. This one woman did to me, and she did it in 2 months. I applied for DHHS benefits, and in 2 months she destroyed my house, caused $15,000 worth of damage, and signed me up for Social Security Part B. That's fraud.
Okay, and I appreciate that, I understand that.
Okay.
And so, here's my concern. Again, so, Tuesday, when you come back, when we start the trial, I'm going to have to go through these People v. Anderson factors with you again. And every time you come to court, I'm going to have to go through that to make sure that you want to continue to represent yourself.
Is it possible we can give it an extra 2 weeks? Is it have to start next week? Because how are we going to get all this done by?
The trial date's set. You've been really complaining for a couple of years that you wanted a trial. I agree with you. You should have one.
Right.
And
I just like it to get.
For the record, we had one scheduled last year, and he failed to show up.
Yeah, that's my understanding, Mr. Schwartz. This matter was set for trial last year, and for whatever reason, I'm not pointing fingers, for whatever reason, I'll just say you weren't available that day. How about that? And so, yes, Ms. Dale.
Your Honor, I do want to express one concern. Mr. Schwartz has provided the court and the prosecution with a list of the witnesses who he would like to have called. There is a question in my mind as to how those witnesses get subpoenaed. Now,
That's what you're for, Ms. Dale.
well, Your Honor, frankly, although I believe I've been very supportive of Mr. Schwartz and his desires to present the case in the way that he wants to, frankly, if I were trying the case, my trial strategy would be different. So for me to sign subpoenas for witnesses under Mr. Schwartz's trial strategy, I just have concerns about me signing those subpoenas and needing to, I guess, defend signing those subpoenas. Frankly, I think it would be more appropriate for Mr. Schwartz to be able to present the witnesses who he would like called to the court, and then the court to issue subpoenas. I could assist in having those subpoenas, sent to the witnesses, but in terms of actually signing the subpoenas, I don't think that would be appropriate in my capacity as standby counsel.
And I certainly appreciate that. I also, likewise, though, don't believe that it would be appropriate for the court to have to engage pre-trial in weighing who is an appropriate witness and who isn't. And so if I get brought into it, and just looking at this and not knowing anything more than I know today, I would not sign a subpoena for Senator Debbie Stabenow. I would not sign a subpoena for Kevin Daly. I would not subpoena John Miller. I mean, it creates a real problem, and I understand that. So I'm not...
John Miller told me that he would make this case disappear. And now I can't call him as a witness and have him tell the court that?
No, the rules that are included in what are called our rules of evidence, no, you can't. That's why, I am very concerned about you representing yourself. You want to talk about, and I've been very patient listening to you this afternoon, you want to talk about a whole series of events that you say are related, but yet, if based on only what I've heard today, I'm trying not to prejudge anything, because you're entitled to your day in court, but you are talking about and keep bringing up things that, in my humble opinion, sitting here this afternoon, don't have anything to do with your resisting arrest.
The fact that they destroyed my house and cut off my water supply that I couldn't get water, that has nothing to do with why I was arrested?
Mr. Schwartz, this is about not you being arrested, this is about you resisting arrest.
I didn't resist arrest. That's why why don't you make this quick and do a polygraph on this?
Well, number one, polygraphs are not admissible in evidence. This word evidence keeps coming up again over and over. It is a real problem for you potentially in the presentation of your case. You can't just, I don't know if you've ever heard the expression, you throw things against the wall and you see what sticks. That's what I'm concerned about in what you're talking about. You're going to throw a whole bunch of things against the wall that don't have, frankly, anything to do with this case. And you're hoping that the jury will somehow read into it, or this is, to me, in my opinion, and I don't know anything other than what I've read in the file.
The thing is, I lived it, sir. They destroyed my house, and then when I tried to get water, and then they arrested me. That's not rocket science.
I agree with you. It's not. It's not rocket science, and I strongly...
Why was this cop was waiting right across the street stalking me? Because, and I filed a U.S. Justice Department complaint against them 8 days prior to them stalking me. If that's not relevant?
I'm going to stop you.
Yeah.
You just keep talking, and your response to one question then leads into all of these other things. I'm really trying to be patient with you. You are not going to be able to act this way next Tuesday when trial starts. You're not. I'm going to also indicate to counsel something I don't think I've ever done before. I'm going to be doing your jury voir dire, or we will never get a jury pick. Ever. I'm convinced of that. So on the list of things to do for Friday, I need proposed voir dire questions that you would like me to ask. They can be as detailed or as minimal as you would like. I can only imagine how long it would take to pick a jury if I don't do it myself. And that is something I've never done and didn't anticipate doing. I thought Ms. Stammel was the attorney. Now that Mr. Schwartz, you're representing yourself, talk about details and rules. Talking to a jury and interviewing jurors as to whether or not they're qualified to sit as a juror in your case is really technical. There are certain things.
I agree, that's why can't Megan do that for me?
You don't get to have it both ways. She's either your lawyer or she's not.
She was supposed to be my court-appointed assistant, just like Fred Miller.
There are assistants. What does an assistant do? They assist, right? Right?
Assist me with the bureaucracy of trying to get the right forms and the right things to say it correctly. That's all I need.
But she can't say it for you. That's the problem. I've watched her. She seems like a very fine lawyer. Why in the world you wouldn't want her to represent you? I don't know.
Why don't you take a look at my last two and that'll answer the question.
Please stop. I'm not trying to threaten you. If you act like this next week, you're either going to be out in the hallway or in the back row, and you're going to have to just sit there and be quiet. You have to stop.
No, you know what? I'm not going to take, I guarantee you this, I'm going to tell you this right now.
Stop interrupting me. You understand that? Courts also have this thing called contempt power. Have you ever heard of it?
I know what you're going to try to do is anything possible to make me lose this case.
That's not true at all. I'm trying to do everything possible that allows you to defend your case in the way you would like to. What you are doing is preventing you from being able to represent yourself.
You know, with me that dragged this out for 4 years?
I have nothing. I
know, that's the problem. You don't know, sir, and that's the problem. You could be the greatest guy in the world, and you'd be the best of friends walking out of this. But right now, you don't know what happened. You don't know what I've went through. I had to fire Colleen Starr.
I don't want to hear about it anymore. I don't. I know that there are rules, like I told you, there are rules when you walk into this room. I am in charge of what happens in this room. Not you, not Mr. Fitzpatrick, not Ms. Stammel, me. I get to control what happens in here. It may not be fair, it's just the law. You can do whatever you want to do outside the courtroom, not in here. We have rules and I will enforce them. You'd be really well advised to listen to what I just said to you.
I've done enough research on the law in this case alone, and I'm not picking people off the street and trying to blame them for anything. Every person on that list is responsible for what happened while I was out of water. You can't blame somebody for an action. I was in a crisis. Why was I in a crisis? Because they destroyed my water supply and I was without water for 5 days.
I'm going to ask you really simply, maybe you can help me, maybe you can't. Did Officer Ryan Wilson destroy your water service? Did he?
No.
No, I didn't think so. How about Officer Steve Best? Did he destroy your water service?
No.
No, I didn't think so.
I tried to file complaints against the people that did, and they wouldn't take the complaints. You understand that?
You have lots of issues involving lots of people.
It's not my fault.
I didn't say that it was. You're so defensive.
I can't help it. This has gone on for, look, how do you make 266 evidence videos without dedication? I want this over with. I have a right to live. I have a right to defend myself. I'm not guilty. I don't care what you say to me, what you do to me. I'm not giving you 2 cents or 2 minutes of my time when you walk out. And you want to arrest me right now, do it.
What are you talking about?
I guarantee you, no matter what happens in this case, no matter what you give me, what they try to do, Judge Bernard tried to give me, she made me an offer that for 2 years I got to meet the judge and go sit on her lap and I got to pay her a fee, and that's my punishment. That's the only offer they made me. They could have offered to dismiss this case and not wasted. You know how much money they've wasted? If they would have fixed this, if they would have fixed my house back in 2017, we wouldn't be here right now. And that's why I called the Alabama police know all about it. Take a look at how many phone calls I made. Those people they're expert witnesses too. They have a duty to if somebody these are police officers. If somebody's breaking the law, they have a duty to protect me against that. The reason that I had a warrant out for my arrest is because I couldn't get transportation to get to court to dismiss a warrant out for my arrest in Macomb County for the same issue, trying to get water. This happened in May of 2019. I got arrested. I was driving down the street trying to get water, and a state police officer flashed my license plate and found out that I didn't have insurance. So he pulled me over and took me to jail, and he left my wallet in my car, so when I got to jail, I didn't have the $100 bail, so they kept me in jail for 6 days, and on the sixth day, I went on a hunger strike, and the 4 police officers came into my jail and beat me up so bad I had to go to the hospital. And then they when I went to the hospital, they realized what they did. I tried to file a complaint. Against the prison guards. I couldn't get the secretary. I couldn't get Lapeer County 911 to send a state police officer for me to take the complaint. I got that all recorded. This all happened. This is one after another incidents where the law, the judicial system is sabotaging a disabled senior citizen's right to live. You made it impossible for me to live.
I can only speak for myself. Don't know what happened before I got here. Again, trying to make sure that you have your right to a trial, trying to make sure you can defend yourself. I need a witness list. I need an exhibit list. Sounds like we're basically in agreement on the jury instructions. Ms. Nabel, you'll look at the composite instructions to make sure.
Your Honor, just as it relates to the composite instructions, I know Mr. Schwartz has so far deferred to my opinion as it relates to the instructions. The only ones that I would really take issue with are numbers 3.3 and 4.7, which is defendant not testifying and stipulation. Those may or may not be applicable at the conclusion of trial, depending on whether Mr. Schwartz chooses to testify or not, and depending on whether there are any stipulations.
So that's certainly fair, and that's the type of thing we can address, during the scope of the trial. I mean, obviously, these are not anything that get read prior.
But otherwise, I would recommend to Mr. Schwartz that he agree to these instructions. These are standard instructions. I guess I'll want Mr. Schwartz to be able to review them.
Absolutely.
But I guess I'm just placing that on there.
No, I appreciate that. Again, that's something that if there are objections, I need to know them by Friday.
Your Honor, I don't think there were ever any motions in limine filed in this case. The one thing that I would ask, I hope it would not be objectionable, would be a request for an order that the nature of Mr. Schwartz's warrant, specifically that was a warrant for carrying a concealed weapon, that not be brought into evidence.
That was dismissed.
I believe the fact that they would testify that Mr. Schwartz had a warrant would be appropriate. However, I believe it would be unfairly prejudicial to Mr. Schwartz for the officers to testify that it was a warrant for carrying a concealed weapon. And so I would ask for a pretrial ruling, and I apologize to Mr. Fitzpatrick that I didn't bring this up sooner, but I would ask for a pretrial ruling that the nature of the warrant not be admissible.
I certainly will consider that in terms of if you want to weigh in on it.
Judge, I'm not going to lie. Until Ms. Dable just said that, I had no idea what the warrant was for. Wasn't planning on discussing it, other than the fact that within the video it's clearly evident that there was an outstanding warrant. They never go into detail about what it is for. They just simply mention that there's an outstanding warrant. I believe Mr. Schwartz actually acknowledges in that video that there is a warrant. Doesn't say for what, so I have no issue with not diving into what it's for.
Okay, well, that sounds fair. I guess we can, if you want to prepare an order that says that, certainly I can do that.
Thank you, and thank you to the prosecutor.
All right, next week will be an adventure. Is there anything else we need to talk about? Sounds like we've handled the jury instructions, the verdict form. Obviously, Mr. Schwartz is going to have an opportunity to look at the composite instructions. If there are objections, I mean, you raised a couple of good examples in this sample because they may not be applicable at the end of the trial. So, I mean, certainly things to think about, but especially the preliminary instructions, because those are read before the jury considers evidence. If you've had any issues, then you can know right away. Otherwise, I'm going to read those. As it stands, if I don't hear anything,
Is this for me?
the preliminary instructions are going to be as the prosecution is.
I think they're good.
Sounds like we agree on the verdict form, so we're most of the way there. We need the witness list, the exhibit list, and if you were going to play videos, then I agree, then those videos should be shared with Mr. Fitzpatrick's office. I believe, Mr. Fitzpatrick, you only have 2 exhibits.
I have some photographic exhibits, and then I have it's actually Mr. Schwartz's GoPro recording of the events that afternoon.
How about the Steve Best smartphone recording? He was recording the entire arrest, and I've been asking for that too. That's the thing. So I contacted Mike Sharkey for 6 months trying to get that, and they wouldn't respond to me. And the Elmont police gave me bad information on how to file complaints. All they did was sabotage me.
Can you give Mr. Fitzpatrick any?
Yes, Your Honor. I've spoken to Officer Best about that, because in the video it's clear that he's also holding his phone recording. I asked him what happened to that phone, and it was turned in, lost, destroyed, whatever the case. We don't have that video, never have, and if we had, we would obviously provide it to Mr. Schwartz. It just doesn't exist at this moment. certainly going to ask Officer Best about that when he's on the stand. He wants to go down that avenue.
All right, and Mr. Fitzpatrick, just so it's fair for both sides, I've asked Mr. Schwartz to provide you with documents and exhibits. Have you provided him with exhibits?
Everything we have already provided to either Mr. Schwartz directly, but more than likely it was provided to his previous assistant counsel, Fred Miller. All of the paperwork, we have proof services for all those things, so it has been provided in the past.
And Your Honor, when I came onto the case, I received an email from the prosecutor's office containing over 200 pages of documentation. I did forward that email to Mr. Schwartz. I highlighted some of the things within it that I thought he should take a look at, like, for example, the photographs. So I've provided Mr. Schwartz with everything that I have received from the prosecutor's office as well.
All right, I just want to make sure everybody understands both sides, that if you haven't provided it to the other side, then there's a really good chance I'm not going to allow you to use it at the time of trial. So no trial by ambush, no secrets.
That being the case, Judge, just to be extra precautious on my part, I have a copy of DVDs, the videos that I plan to introduce on this. It's a thumb drive that I can provide to Mr. Schwartz. It's his GoPro video. I think he's seen it, but it's just an extra copy in case he hasn't.
All right, I agree.
Oh, you can say, is that just my video?
Yeah, that you took with your GoPro that day. It's just a copy of it.
Do you want it?
No, that's for you.
Okay, thank you. Now, this is a hard drive, and I've got 266 videos that I need to give to somebody here today.
Is that a copy of those things that you've made?
Yeah, it's all the videos that, Megan told me that I had to give MP4s.
Yeah, well, Your Honor, I advised Mr. Schwartz that these videos that he has been maintaining on YouTube, that it's not, that because web addresses aren't a static form of tangible evidence, that we needed to have something tangible that could be introduced as an exhibit. And so I asked Mr. Schwartz to put his videos onto either a disk, a flash drive. He put them onto an external hard drive. Unfortunately, because of the costs of duplication, he only has one to be able to introduce into evidence. I know that his exhibits are accessible online. I don't know if it would satisfy the prosecution to be able to have a web link of where he can access them, or if the prosecutor's office has an external hard drive that we could transfer the videos onto.
That's
We
me.
don't, and I do not feel like spending the entirety of my weekend scrolling YouTube to find if these things exist or not.
Oh, I agree. I think it was a fair request to see if you had a hard drive available. I mean, it is Mr. Schwartz's obligation to provide copies. So however he does it, he needs to do it. I agree. Online links to YouTube channels is not appropriate. The court's order says you have to provide copies, so we need copies.
And Your Honor, I do understand that. However, there has been a finding that Mr. Schwartz is indigent, and so in terms of the costs of duplication, I don't know if that's something that the court can assist with.
Any idea, Mr. Schwartz,
I'm not sure what we're
the
doing.
storage amount, what's required of your videos, do you know?
Well, this is 1 terabyte. This was $60 that I had to pay for this, just to get it done, and I got it done.
No, what I'm asking is, you may have a 1 terabyte hard drive. Does it need all 1 terabyte?
No, it's about a quarter of that.
That's what I wondered. Okay.
Right.
All right, I'll figure out something.
I tried to do it, this morning I tried to load it on a thumb drive like that, and I just ran out of time because it was running so slow, and this is real fast. I mean, can I give this to you now? I mean, what am I going to do with it? I was told to bring this in.
I'll leave that part of it to you two. I'm not going to get involved in that. However a copy is provided, it needs to be provided. I don't know if that's something that maybe you two could agree, and maybe Mr. Fitzpatrick could have someone in his office tomorrow download all that stuff onto something. I don't know. But that's up to you guys. That's not up to me.
It's not hard to do it. I just ran out of time. I tried to load it on a small drive. I ran out of time.
And Your Honor, I guess I would just, on Mr. Schwartz's behalf, ask for some type of consideration short of Mr. Schwartz having to go out and bear the costs of replicating the electronics.
If I have to go buy a thumb drive myself, I will do it.
Judge, if you don't need a copy, if that is just a copy of everything, then I could take that.
It sounds like that is his sole source.
That's my worry, is that it's his sole source of those breakdowns that he's going to need to create the list that you've ordered him to create.
Right.
So if I take that, I'm afraid he's kind of going to be starting from scratch again, more or less. Now, if he wants to provide that at the time that he provides the list to us, that everything's on there, then that would suffice from an evidentiary standpoint. To me, as long as the court doesn't need its own copy.
I am not going to look at those videos in advance of the trial, I assure you. And so if Ms. Stammel, perhaps to sort of facilitate this, if you will front the cost of whatever drive we need, it sounds like we don't need anything that big or anywhere near that big, so we're talking probably $20 or less, then I will make sure one way or the other that you are reimbursed for that cost.
Okay, thank you, Your Honor.
All right, anything else we need to talk
Are you
about?
taking this today or no? I'm not-
I'll talk to you.
Okay, I'm confused.
Is there anything else that you think we need to address before? Mr. Schwartz does not have, I guess there's nothing additional on behalf of Mr. Schwartz today.
Thank you. Mr. Fitzpatrick, anything else? All right, very good. Keep Friday's date in mind for those things that need to be provided, and then I'll see everybody on Tuesday. And key, though, for me, proposed board here.
Yes, sir.
Thank you very much.
So when we're doing with this,
Do you have a list of everything that's on there, or?
right, that's what he wants.
Well,
I mean, the thing is, if you take a look at the list,
if I make a copy, if I take this from you so that I can make a copy of it, do you somewhere have the information that you need in order to create an evidence list?
what?
Remember the judge said you need a list of all of the videos? Would you be able to just pull that from your videos on YouTube?
You know, what I did is I made this, I took this and I downloaded the whole thing onto my computer. I tried to,
Okay, so you have a copy of this on your computer that you can use? Okay, so then what I'll do is I will take this from you and I will make a copy of it and give it to the prosecutor on Friday. So what you need to do is, here, let's kind of divvy up assignments here. So, the voir dire questions are questions that you ask a jury to find out if they're going to be fair jurors or not. I've done like 50 plus jury trials. I've done a lot of voir dire questions. Would you like me to prepare that list? Okay. You know, I've got kind of some ideas of, you know, the types of jurors that might be good on the case.
old people. That's what I want.
People who are not just going to come in and blindly agree with someone who's wearing a police uniform. So what I'd like you to do is take a look at these composite instructions and just let me know if there's anything that jumps out to you. I think these are standard things. I think they're fair. And I want you to do the list of exhibits. You know, that's something that really I can't really assist with. So
I can do that.
do that and make sure you email it to me. I'll be here on Friday.
A list of, and then you want a list of the videos, and then you also want all the witnesses
All
you
the
want
witnesses,
to
yeah.
explain why.
Yes.
Okay.
So you focus on the exhibits and the witnesses, and then I'll kind of work on the voir dire and, did you understand what I was saying about, you know, not talking about the type of warrant? I didn't want the police coming in and being like, we pulled him over because Rick Schwartz, he had a warrant for carrying a concealed weapon. You know,
See,
they don't need to know that it was a carrying a concealed weapon warrant. All they need, the only reason why that's even relevant is because that's why they pulled you over. So I just didn't want them to, I didn't want the jury to hear weapon and think, oh, this is a bad guy.
in 2008, in May of 2018, I tried to get water, and I got pulled over in Romeo, and I had a little kid that was driving my car because I couldn't do it legally. So he was driving my car. He left his target pistol in my car. You know, I didn't even know it was there. So, but what they did, they tried to arrest me. They arrested me and they charged me with weapon and all that. They were going to try to nail me to a cross. You know what they wound up getting? $200 ticket. $200 ticket. And the reason that I let them do that is they said this Americans with Disabilities Act. That's how I beat them. You know, I couldn't make it to court. I'm going to call this other attorney, this McComb attorney who sabotaged my case. You know what this guy did is he gives me a court date. I go to court. He's not there. The court knows nothing about it. And I pay $150 to let somebody drive me there. So then, I'm calling. I called his office, and they go, "We don't know what happened. We don't know what happened." And then they say, "Oh, we got another." I called on a Friday, and they said, "Oh, we got a new court date for Monday." I go, "I don't have more money." I said, "Have the attorney tell the judge I can't make it." And he went and said he failed to appear. So they put a warrant out for my arrest.
Right.
That's why I'm going to call that prosecute.
Okay, well, make sure all of that's on your witness list. I have to go. My husband had to go get my kids from...
Do you have a little baby?
Yeah.
I heard you have a baby.
Yeah.
How old?
11 months.
Oh.
11 months and 2.5. So I've got two
You got
of
two
them.
kids?
Yeah.
Good for you.
So yeah, my husband's on baby duty this afternoon. So what I'm going to do too is I'll kind of go through I'll send you an email kind of letting you know some of the things that I think you should kind of focus on when you're preparing for trial, just so that we make sure that you're as prepared as you can be.
Just wish they'd postpone another couple of weeks. How do we even get the subpoenas to these people?
I don't know. So, you know, we'll submit everything on Friday, and then, you know, if Tuesday comes around and we're not prepared, we're gonna let the judge know that.
Okay. Is this,
So yeah, that's for you. These are just a couple things that I just jotted down in case.
is this stuff I could look up? Is that
Yeah, so
okay?
the one, this was the, he was going through that like list of things. He was like, these are the factors about representing yourself. That's People versus Anderson. So I just wrote that down for you. And then you had talked about having John Miller present, and his offer to make the case go away. So that is considered an offer of compromise. And so that's something that under the rules of evidence is not admissible. So just like, you know,
I
like.
can't say that.
No, so like, let's say I have a client who is guilty of stealing $1,000 from a store, and I know that they're guilty, and I want to get the prosecutor to agree to reduce it down to under $200. You know, I would say, you know, he's ready to pay, and he's going to plead, and you know, he'd be willing to do it under 200 instead of over 1,000, and you know, and then we couldn't come to an agreement. You know, the prosecutor wouldn't be able to come into trial and say, well, the defendant's attorney offered to reduce this down, you know, offered to have him plead to something in this case. You can hang on to that.
Isn't that important?
All right.
Do you think that's important? I filed a complaint against them, and then they stalk me.
Yeah.
And then they refuse to respond. I mean, how can I?
So
Well, I have a legal right to do that.